right. We're here on Kouri Richins versus Katie Richins-Benson in her capacity as trustee of the Eric Richins Living Trust. Have counsel for Kouri make their appearance.
Thank you. Lazaro and Austin Nate for Mr. Richins.
Very good. Welcome.
James Tracy and Jacob Gorange for defendant Katie Richins-Benson in her capacity as the trustee of the Eric Richins Living Trust.
And Ms. Chandler.
Deborah Chandler on behalf of the minor children.
Very good. All right. We're here on three motions. They are related, so there may be some going back and forth as we address related issues. Why don't we handle the motion related to plaintiff's seventh claim for relief first? That's the motion for partial summary judgment related to the Voidable Transfer Act. How best to start here? Mr. Nate, are you doing the talking on this one?
Yes, Your Honor, I am.
Why don't we start with you? May I ask you a couple of questions?
Yes, Your Honor, please do.
First, in your view, how does the fact that a transferred or revocable trust doesn't put assets beyond the reach of creditors affect the application? How does it, the argument, right, is it's as if the assets weren't transferred from a creditor's perspective. They're still reachable under Utah code.
So I think there's two ways to address that, Your Honor. And the first is, and of course, as you mentioned, there's bleed over into the other motions that are issued. And I think this particular issue, lends itself to that specifically. Because one of the positions that the defendant has taken in this case is that Eric no longer had anything to convey to him or convey to Kouri upon his death. And essentially it was out of her reach at that point because it had been transferred to the trust.
Right, but I'm asking you a different question. So put that as your side. Let's assume that the money, the buy-sell proceeds, if I recall correctly, nobody in the case is asserting, or Kouri, is not asserting, unwind the assignment, I want the membership interest. Rather, she's asserting an interest in the full amount of the buy-sell proceeds. Is that correct?
That's correct.
Okay. And so let's assume for the purposes of our discussion, just for now, that that's $2 million sitting in court that she asserts a claim to, and that she is a quote-unquote creditor. Why is her ability, interest, efforts to secure her interest in that $2 million hindered, delayed, defrauded in any way by their fact that they're currently being held, at least nominally, by the revocable trust? Can she reach them?
Right. Yes, Your Honor. I think she absolutely can reach them. And, that's why we cited that in our reply in the votable transfers motion, is because we think that position is diametrically opposed to the other positions that's been taken with respect to the motion for summary judgment, the cross motions for summary judgment. We think there's some conflict there. And so in the event, as we believe, that under the Utah code, she can directly access that under the arguments that have already been made, then the voidable transfer, I don't want to say it's not necessary, but I think there's a much clearer way to resolve the issues that are outstanding here instead of setting the transfer aside, if that makes sense.
I agree with the last part. I think with respect to everybody that's filed a motion here is that's for more relief than they're entitled to, if they're entitled to any. Your motion, though, seeks a ruling as a matter of law that this was, in fact, a voidable transfer and that it should be unwound, meaning nominal title to that $2 million should be held in the name of the estate of Eric Richins, not the revocable trust established by Eric Richins. Am I right about that?
That's correct, Your Honor.
Okay. But it's the same from a creditor's perspective, right? Whether you execute a judgment against the revocable trust or you execute it against the estate, there's no difference, is there?
Honestly, Your Honor, I think there may be some difference to a degree, but again, at the end of the day, based off of the defendant's position in the opposition, in which again we reiterate in the reply that it's accessible just simply under the statutes of the trust code, then I think we would agree with you that unwinding the transfer may not be necessary, or we may not even need to get there, simply because if Kouri is in fact a creditor, and I think that's the critical question here, and is admitted in the opposition, that if Kouri's a creditor and therefore has a claim for purposes of the statute, then really there's no need to go through this process of dealing with a voidable transfer because there's a much more direct way of going about it.
I agree there's a more direct way. I think you may be reading too much into their concession. I read their brief as saying, we concede that she falls within the statutory definition of a creditor, not that Eric Richins had a business interest to transfer at the time of his death. He'd already transferred it in a way that doesn't breach the prenup.
Right. And I don't want to correct, I don't want to, say what their position is or anything. I'm sure, they'll get up here. I do think they do dispute that Kouri's a creditor, though, in the briefing. I think they dispute that there's a creditor-debtor relationship that existed here under the underlying documents and the claims that have been asserted. It's very clear a creditor is an individual that has a claim, and a claim is defined very broadly under the Act. So we think, as a matter of law, Kouri is absolutely a creditor under the Voidable Transactions Act. And
but given the breadth of the definition of creditor, isn't it true as a matter of law that you can be a creditor by virtue of an allegation rather than an adjudicated fact, right? That's
correct.
Position.
Right, exactly right. The statutory language says it can be a disputed, unliquidated, contingent, right to payment. And so, clearly we say that Kouri is a creditor under these circumstances. But with respect to, my recollection is that the position that a transfer to a revocable trust can't constitute a, voidable transfer for purpose of the Act. My recollection is all the case law is foreign case law, nothing that would be specifically binding on this court. And at the end of the day, we cited case law, which I will mention as well, is from an outside jurisdiction, but we think it's illustrative that these types of revocable trusts can be used as an instrument to do exactly what what the Voidable Transaction Act seeks to avoid, which is to put things outside of the reach of creditors under that very broad definition. And specifically the Pandy case from Colorado that we cited, again, recognizing that it is, not binding on this court, but it specifically addresses the idea that a debtor should not be able to have all the benefits associated with a revocable trust to the detriment but be able to shield that from all the creditors.
But if I read the Utah Probate Code correctly, there is no limitation on the post-death susceptibility of an asset that was contributed to a revocable trust during the testator's life to claims of creditors. It's as if it was just sitting in the estate of the individual, right?
I think you're correct, Your Honor.
Okay.
Yes.
And so I think their argument was categorically, as a matter of law, transfers to a revocable trust cannot be within the purview of the Act. Now, in fairness to you, you say, all right, they're not in the purview of this section of the Act, but what about the no equivalent value? Would you acknowledge there's at least an issue of fact as to whether or not $2 million is equivalent value? I don't know that I can grant summary judgment on that.
Could you clarify your question? An issue of fact on the value on that value, or
two different sections of the Act?
Right, correct.
Or two different, I guess we'll say, silos of the Act. One is creditor, debtor, transfer with the intent to hinder, delay, defraud. That'll be category number one. But then there's a second category of creditor, debtor, transfer, not for equivalent value, substantial value.
I think it's reasonably equivalent value.
That would not be affected by the assignment, right? Or I guess that would not be affected by this argument related to categorically putting in a revocable trust. That's a separate issue, right?
Right, yeah, I think so, yes.
But here you are asking for summary judgment, meaning undisputed facts, ruling as a matter of law. This was, in fact, a voidable transfer. In order for me to rule in your favor on that second category of argument of the Act, I would have to rule as a matter of law that $2 million wasn't enough, right?
So that the $2 million was not. So let me make sure I understand your question, Your Honor. So under Section 203, I think is where we're operating this second group, right? In order for a transfer to be voidable, there needs to be in fact, do you mind if I just pull it up? That might be the easiest. I don't want to misquote it here. Assuming my technology will work. There we go.
25.6.202.
So 202 is actual intent to hinder, delay, or defraud, and 203, subsection 1, is that a transfer is voidable if the debtor made the transfer without receiving a reasonably equivalent value in exchange for the transfer, and 2, the debtor was insolvent at the time or became insolvent as a result of the transfer.
And what I see them saying is myriad issues of fact. You haven't proven it based on undisputed facts as a matter of law. What's your response to that?
Our response is they haven't provided any evidence any admissible evidence to the contrary, right?
You have the initial burden here of persuasion, and they're saying you haven't met it. Tell me why you haven't.
I think we met it, Your Honor, because first we have the testimony of our client as to the assets that were owned that she was aware of at the time of the transfer. In addition, we have, the additional debts that we know existed. I don't think there's any dispute as to at least the first mortgage debt. Certainly there's a dispute as to the second one right now. But even if you disregard the second mortgage, with respect to the first mortgage, they haven't identified, or we have come forth with evidence, testimony from our client, stating that Eric's assets did not exceed $200,000, but that his debts did exceed $200,000, and we have that demonstrated by solely the amount of the first mortgage on the house, right? So with that testimony and providing, the fact that debt existed at that time, we think we've met our initial burden to demonstrate that those were the amounts of Eric's assets, those are the amounts of his debts under the terms of the act that constitutes insolvency, and therefore...
Run those numbers by me one more time. I didn't hear you say the words $2 million.
Correct. I did not say the words $2 million. And I think here, because the focus is on the debtor receiving a reasonably equivalent value, so that would be Eric receiving value, not the trust, right?
Your entire argument, though, that he as trustee and he as individual are one and the same for the purposes of this analysis, and so if he as trustee is going to receive $2 million from the buy-sell, he as individual receives it as well?
To a degree, yes, Your Honor. I don't know that we would say that it's, yes, we think functionally it is one and the same, but again, we are taking the arguments that we've received from the other side that there is this distinction here, right? And so, had the position been taken that, or without the initial position that the fact that Eric did not possess, or own this upon his death, if that position was not taken, it's highly unlikely we would have brought this motion in the first place.
Let's talk about the prenup for a second. I understand your argument to be by executing the assignment, Eric breaches the breach to the prenup by effectively diluting Kouri's interest in buy-sell proceeds by 75%, right?
Correct.
Could Eric have sold his interest during his lifetime in C&E for $500,000 without breaching the prenup?
I think he probably could have, and I think that's where the distinction comes into play. I guess to clarify my previous answer to your former question is we haven't alleged necessarily that it's a breach of the prenup in this case yet. I think the argument is more that irrespective of Eric's transfer to the trust, the prenup remains binding and therefore is still enforceable against the trustee of the trust.
Well, wait. If the answer to my question is he could have sold his interest for $100,000 without breaching the prenup, how is that different than what he affected by the assignment and the buy-sell?
I think with respect to the assignment, the distinction here is that if he just went ahead and sold it to a third party, then you have a third-party purchaser who, presumably took for value, took for consideration, and therefore would have all the defenses and rights associated therewith. Frankly, if it was sold to a third party, I don't know that our argument remains the same or stands here today, right? Under these circumstances, though, Eric essentially transferred the interest to himself as a trustee, right? So it's different. Our position is different and distinct than a sale or a transfer to some sort of a third party.
Well, he transferred it to himself as trustee, pursuant to an agreement that maintained an interest in Kouri, albeit 25% of which he had the moment before it did. But if he can choose the sales price, how is it effectively different?
And I guess I'm not sure. Could you explain the 25% versus 75%? Maybe I'm missing something
There are
here.
4 beneficiaries.
Okay,
Under
understood.
that table's version of it, there's
Gotcha.
one under yours. There's $2 million at stake. So sell it for $500K. Why can't he do what he did?
Again, it's a fair question, Your Honor, and I think it's not necessarily in terms of what he could or couldn't do, but the fact that he transferred it to the trust or himself as the trustee, and the prenup specifically imposes those rights and obligations to successors and assigns. And so in that capacity, we would say that it's still enforceable as to the defendant in this case.
But Eric had donated his business interest in C&E during his lifetime to a charitable organization. Spinning hypothetical here, come to the conclusion that, you know what, I'm done working, this has been great, I'm going to go be a hunting guide. I'm going to donate my interest in C&E, this thing I worked so hard to build, to the church, to the nonprofit organization that maintains open lands for hunters and fishermen. Could he have done that?
I think potentially he could have. Do I think that there are still potential claims that arise therewith? Yes. And I mean, it's difficult to...
What would the claim be?
Well, I mean...
It's his sole and personal property by the four corners of the prenup. He can do whatever he wants with it during his lifetime, right? If it increases in value, she has no, Kouri has no claim to that increase during his lifetime. I guess what I'm trying to ask is, why doesn't that give him the full authority to alienate it during his lifetime?
Right, and again, it's I think it's a fair question, and it's difficult to state in these hypotheticals, particularly when, you know, given the amount of work that's gone into this business, the idea of donating it to a charitable contribution, sure, it's possible, right? But again, at the end of the day, we think it comes back down, if you look at the plain terms, yes, it is unequivocally during his lifetime, it is going to be his sole and separate property with this single contingency, correct? And we believe that contingency occurred in this place, and that the transfer to the trust, I mean the effective transfer to himself, perhaps may be the only circumstances where we would be bringing the claims that we're bringing, but don't think that undermines the validity of those claims.
I understand your position.
Thank you, Your Honor.
Counsel.
Yes, Your Honor.
Start with the last issue. Well, actually, no. Start with the voidable transfer.
The voidable transfer?
Yeah.
Well, Your Honor, we agree that the problem with the voidable transfer, it doesn't fit the facts of this case. It doesn't fit. A voidable transfer is a remedy for creditors to get at assets that debtors have tried to put outside their reach. As you mentioned, and we've cited in 75-7505, it's very clear under the trust code that assets held in a revocable trust are subject to the claims of the creditor during the grantor's lifetime.
What about the section 203?
Well, so 203, now that, and I do think it's important to look at the difference between section 202 and 203. To remind ourselves, on section 202, that's where you have a claim that arose either before or after the transfer. I don't see how Kouri could have possibly had a claim before the transfer, but we could talk about that.
Prenup was in existence before the transfer.
Right, but what claim did she have?
Well, it would be the contingent claim that by this transfer you are undermining that which you agreed to in the prenup. Now, we have a whole colloquy I just got into with this, I've done it anyways, but
Exactly.
the Act provides a different overlay.
It does, but I think it's an important point to talk about whether she was a creditor, whether she had a claim, and if so, was her claim before or after the transfer? I think that, and we do take the position that she wasn't a creditor, that she didn't have a claim. But let's take your hypothetical. Before the transfer to his trust, let's say he sells it for $500,000 to a third party. Does Kouri have a claim?
Maybe the $500K, I think that's what Mr. Nate says, that's traceable at this point.
The question is, though, did he breach the prenup? And I think, as Your Honor noted, he could have done anything with it. So our position is there was no breach of the prenup because Eric wasn't obligated to keep it in place for her. If Kouri was worried that he might do something like sell it, she could have negotiated that as a part of the prenup. She didn't.
But in fairness, and without naming names, I'll give you an example that's come up in a divorce case in Summit County. Husband transfers an asset to a third party, gets a divorce, reacquires the asset. It looks like a sham. The Act applies to that situation.
Absolutely.
And so if that's the case, why wouldn't, I mean, we can't say that the Act doesn't apply categorically if, for example, spinning a hypothetical here, Eric transfers his business interest in C&E to a third party for $100 or $1. After his death, his estate, the trust, maybe his kids reacquire it for $1. It starts to look a little more shady. And so that didn't happen here, I acknowledge. But in terms of trying to determine whether or not the Act can apply to the facts of this case, why don't we have to contend with Section 203?
Well, let's look at 203. We don't think she's a creditor under 202 or 203. And the reason is because the prenup did not restrict Eric in any way from disposing of his asset, and that governs. If he had disposed of it, she wouldn't have a claim. So we don't think she's a creditor. That's our position. But let's look at 203. 203 applies for claims that arise before the transfer, not after, and if the transfer was done without reasonably equivalent value and you're insolvent. Well, first of all, when you make a transfer to your revocable trust, well, and particularly in this case, the trust says all of those assets, every penny, are available for Eric's use. They cannot show it wasn't for reasonably equivalent value, because if he had, by the way, what did he have? He had a business that's worth at least $2 million. He has a house that's worth $1.7 million. The first mortgage was $260,000. The second mortgage, which we think was fraudulently obtained with fraudulent powers of attorney, was $250,000. But even if you take those together, that's $500,000 on a $1.7 million house. Plus, Katie filed a declaration that says he's got other funds, stocks, vehicles. I don't think this is a close call on solvency, but they clearly can't meet the burden of proof on insolvency. But in any event, Your Honor, there's clearly, if you take what we just talked about, $2 million for the business, $1.7 million for the house, minus maybe $250,000 for a mortgage, you're well over $3.5, potentially $4 million. Every penny of that in the trust is available for Eric. How can that not be reasonably equivalent value? It went from one place where he could use it to a trust where he can still use it.
So in terms of the ruling you'd request on plaintiff's motion for summary judgment on their seventh claim for relief, you didn't file a cross motion on that claim.
We didn't.
Is it just deny the motion, or is it rule as a matter of law that transferred or revocable trust is outside the purview of a 202 claim and deny the motion, the remainder of the motion?
Yes, the latter, Your Honor. You know, as it goes in summary judgment motions, you may not file a motion, but if the ruling comes down, it's law of the case, it effectively disposes of the claim.
Well, it disposes of that part of the claim.
Yes, yeah. So we don't think she's a creditor before or after the transfer. We certainly don't think there's any actual intent to delay, hinder, or defraud, because the assets are there available to creditors during Eric's lifetime. They can't show that it was without reasonably equivalent value, because all of the assets that were there before were still available for Eric's benefit, and they can't show that he was insolvent. In fact, it looks like he wasn't insolvent. He was solvent by somewhere approaching $4 million on the plus side. So for all of these reasons, we think that the summary judgment motion on voidable transfer should be denied.
Okay. Talk to me about the interplay between the terms of the prenup and then the events buy-sell agreement in June 25, 2019 and the assignment in February of 2020.
Okay.
Your position, I think, is you can do whatever he wants.
He can do whatever he wants. I don't know that the prenup could have been more clear on the fact that this was his, not hers. No part of it was hers. He could do anything he wanted with it. That seems to be crystal clear. Then we get to Section 2, Sub 1, under the title Separate Property of Husband, that says the expenditure of commingled marital funds even on said business. Because they're thinking, well, what if you spend commingled funds? The expenditure of commingled marital funds on said business shall not give wife a claim or right to an interest in said business, or alter the separate ownership of said business, except that if husband should die prior to wife while the two were lawfully married, husband's partnership interest in said business shall transfer to the wife. Well, Your Honor, Eric simply did not own a partnership interest at the time of his death. It was owned by the trustee of his trust in his fiduciary capacity. It so happened that he was the trustee of his trust, but legally that makes no difference. The business interest was not owned by Eric individually when he died. It is not a distinction without a difference. It is a distinction that that Utah law recognizes. If that business interest had been owned by him individually when he died, that would have had to pass through probate. It did not. Nothing in the prenup restricted Eric's ability to sell, transfer, or assign his interest before he died. And again, the prenup makes clear that the membership interest was Eric's sole separate property to do with as he pleased. It seems to me, Your Honor, what Kouri wants is the court to ignore well-established principles of trust law that allow someone to transfer legal title to assets from themselves individually to a trustee. Your Honor, it wouldn't, let me use an example. If Eric, instead of transferring it to his revocable trust, had decided to create a limited liability company, Eric Richins LLC, and he's the sole member, would we be having this discussion? Maybe. They would have to say, well...
The body language I'm getting from that table is yes.
Well, okay, but what would they have to do to get there? They'd have to say, well, for that, you can just Your Honor, just ignore. You have to ignore the corporate structure of the LLC because he's a single member. Well, that's not the law. An LLC is a separate legal entity, and the law recognizes it as such. It's really not much different with a trust. A trustee of a trust holds the legal title for the benefit of the beneficiaries. Real property, and in fact, in this case, the real property transferred from being owned by Eric to being owned by the trustee of his trust. Again, the fact that he was his own trustee doesn't make a difference.
So when I look at the list of relief you're asking for, I think it's different than what you're arguing in favor of. It seems to be what you're arguing in favor of is a ruling as a matter of law that the assignment by Eric of his business interest to his trust in February 2021 was effective and was not a breach of the prenup. Full stop, right?
Yes, but, footnote, even if it were a breach of the prenup, who's your claim against? It's not against the trust. It would be against Eric. And I'm here to tell you, Your Honor, they have not brought a claim against Eric Richins for breach of the prenup.
I think what they're saying is the assignment is valid because he didn't have the authority to do it because he already agreed and they're going to hold some interest or hold the business.
Well, Your Honor, having an assignment or a contract or any other agreement not be effective is a completely different story than breaching it. There's no suggestion that it's not effective. It could be a breach.
Pause for a second. You keep taking on more water than you need to, and I don't understand why. For example, you're asking me to rule that the trust proceeds shall be distributed in accordance with the terms of the trust agreement. Lord knows what kind of equitable or other fiduciary duty arguments are sitting out there. Why would I make that ruling today? Isn't the only thing that's before me today is, does the trust hold the $2 million, period? Or is, no, the $2 million is in his estate?
We are perfectly satisfied with the ruling that the trust owns the $2 million.
Okay. And then the parties litigate whatever arguments they have beyond that after today.
Fair enough.
Okay. By the briefing, less than the introductions to the briefs, I think that's the proper result today. Do you see it differently?
No, we'd be satisfied with that result.
Okay. All right, let me hear from Ms. Chandler.
Yeah.
I was not a party to this when these briefs started, so I will keep it short. There is an extra avenue I think we need to look at, though, the facts of which have arisen since the original briefing. And it's this. Eric died on March 4th, 2022, and under Utah Probate Section 75-3-803, Kouri had a year from the date of his death or 60 days from receiving written notice or notice of publication to present a claim to the estate. While she did initially timely file a notice of claim in the estate case, that claim was solely based on the allegations made in the trust complaint. There are no personal allegations against Eric. These claims were then disallowed by the PR on April 12, 2023. Utah Code Section 75-3-804 subsection 2 requires that a proceeding be commenced within 60 days after the personal representative has mailed the disallowance of claim. To date, there is no proceeding that's been initiated and the time to do so has passed. So...
Wait a minute, this has not been briefed.
It has not, Your Honor.
I'm sure I understand, don't see where things are headed. So,
If Kouri doesn't
the
have...
moment Eric dies, right, the business interests, the buy-sell proceeds, which have not been liquidated yet but are coming, are either in his personal estate or in the trust.
Yes.
Your side of the room says in the trust.
They are in the trust.
The trust gets administered according to its terms. Kouri doesn't have to make any claims, right?
She does have to make a claim if she's going to contend a fraudulent transfer, because Eric has to be the debtor. So on all sections of...
But if it's in his estate, this is where you're telling me some deadlines with harsh results kick in.
That's correct. If she didn't make a claim, but in the estate, and pursue it within 60 days of receiving that notice of disallowance, those claims are now barred.
And when you say claim, is that her argument under the Act?
It would be a claim that she has any claim against Eric, right? Whether it's breach of the prenuptial agreement, breach of the duty of good faith and fair dealing. So without those, a claim on that she owns half the house. Without those, there can be no debtor-creditor relationship, Your Honor. And every section of the Utah Voidable Transaction Act requires a debtor-creditor relationship as a predicate to asserting the claim.
With the, I'm going to put you on the spot here, and I'll understand if you're not prepared to answer. This is new. I'm not going to make any rulings on this today, Mr. But if the house is in the trust, we just apply the trust, right? Subject to acknowledge there's a Slayer statute issue sitting out there.
She can make a claim as to whether she's a tenant in common with the trust.
Right.
But to the extent she has some claim against Eric as a debtor, she's lost that.
Okay. You're going to have to brief that. You
Okay.
can't rule today.
That's fair.
Talk to me about the arguments that were briefed. Anything to add on this?
I think that the argument, there's a valid transfer here. To the extent that that transfer did something that the prenup, I think on the face, the prenup allows for that. To the extent that that violated, I think the only issue would be a duty of good faith and fair dealing. As to Eric or some other frustrates the purpose of the contract, those claims were against Eric personally, and they need to be brought against him personally. I don't know if you can, I don't think that claim goes against the trust, because the trust would be the same as a third-party transferee for the purposes of this. She didn't have a vested interest, and Eric could do what he wanted with this. And so when he transferred it to the trust, it was a valid transfer. It sits in the trust unless she can avoid it somehow. She can't avoid it through the Fraudulent Transfer Act because she's not a debtor.
Because the commission precedent hasn't kicked in yet?
Because, yes,
But the definition of claim talks about contingent claim.
can't be contingent. At best, she had a contingent, unliquidated claim that can now never be liquidated because it's time barred.
Okay, I appreciate this.
I'll keep it brief. So just with respect to the argument that was just made, the claim was disallowed, and then we did file a lawsuit against the estate. That is case number 230500230. It's also in front of you as well. Has not been served yet, but that action has been commenced, and in order to preserve, the claims that have just been served. So I want to make sure that was clear for the record that after the disallowance, we did file a lawsuit within the statutory time period.
Okay. Anything else?
No, that's it. Thank you, Your Honor.
Okay. Mr. Tracy.
No, Your Honor. As far as the issue about the claim, I don't think that's before the court today. We'll deal with that in the other case, I think.
All right, the procedural posture of today's hearing bears noting. We're here on 3 motions for partial summary judgment. No matter what I do today, it does not dispose of all claims between the parties. There will be more litigation after today. With respect to plaintiff's motion for summary judgment on plaintiff's 7th claim which requests a ruling as a matter of law that Eric Richins' transfer of his assets into his trust should be avoided, and that Kouri is entitled to exercise any and all remedies, including those available to her under Utah's Voidable Transactions Act with respect to those assets. The motion is denied for the following reasons. First, with respect to the portion of plaintiff's 7th claim for relief that is brought under Section 202 of Utah's Voidable Transaction Act, the court rules as a matter of law that because a transfer into a revocable trust does not place assets beyond the reach of a creditor, that a Section 202 claim does not apply as a matter of law to a situation where assets have been transferred into a revocable trust. Second, with respect to any portion of plaintiff's seventh claim for relief that is asserted under Section 203 of Utah's Voidable Transactions Act, the motion is respectfully denied because plaintiff has not yet carried her burden of showing through undisputed facts supported by evidence in the record the insolvency and or failure to receive reasonably equivalent value elements of that claim. Therefore, plaintiff's motion for summary judgment on plaintiff's seventh claim for relief, docket 241, is denied. Plaintiff's motion for partial summary judgment, which is docket number 7, and defendant's motion for partial summary judgment, which is docket 249, are related. Plaintiff asked for a ruling as a matter of law that Kouri is the sole legal and equitable owner of the business interest, otherwise known as the $2 million in buy-sell proceeds, that the trust holds no interest right or title to or in the business interest, and that Kouri is the sole and proper recipient and owner of the business interest and any proceeds that are derived from the liquidation of that business interest. Again, the $2 million of the buy-sell proceeds that are currently being held in the court's trust. Conversely, defendant seeks a ruling as a matter of law that CME's operating agreement prevented the transfer or pledge of the business interest, that the prenuptial agreement with its attempted pledging of the business interest is unenforceable, that the assignment that occurred in February of 2021 is valid, binding, and operated to transfer the business interest to the trust, and that the trust is entitled to receive the proceeds from any sale of the business interest, after which those proceeds shall be distributed in accordance with the terms of the trust agreement. Based upon undisputed facts in the record, the court rules as a matter of law that plaintiff's motion for partial summary judgment, docket number 7, is denied. A defendant's motion for partial summary judgment, docket 249, is granted in part and denied in part as follows. The court rules as a matter of law that the assignment of Eric's interest in C&E in February 2021 to his revocable trust is valid and operated to transfer his interest in C&E to the trust. Moreover, the court rules as a matter of law that the trust is entitled to receive the proceeds, that is the buy-sell proceeds of $2 million related to that business interest. The defendant's motion for partial summary judgment is otherwise denied.
Would you like us to prepare an order, Your Honor?
Please.
We will.
Mr. Nate, the motion's to stay. I appreciate your email. How do you want to handle this?
Your Honor, I think we are in discussions. I think we're close to reaching an agreement. It would be helpful, though, if we could get something on the calendar down the road, just in case those discussions fall apart.
There's another summary judgment hearing coming, isn't there?
In this case,
No, we have summary judgment motions pending, but Your Honor, stay those until we have this hearing.
My calendar is well, this is a bit ambiguous, but my calendar shows that we have a hearing on October 18th at 1:30 p.m. in case ending 049. Is that the estate case?
Not familiar with that.
Says 076.
What's that?
is that the criminal case, Your Honor?
No.
I don't know what's your...
Hold on. Hopefully I'm not embarrassing myself here. Let's take a look.
We think that's an unrelated case.
Maybe so. Yes, you're right. My apologies. A lot of Richins in Southern County. My apologies. I apologize for that. Mr. Nate, to your point, I'm going to let you folks talk for another week or two and then tell me whether I want to put a hearing on the calendar or not. I am cautiously optimistic you'll be able to work it out. If you're unable to, file a request to submit. Tell me what you're asking for. I'll work it.
Understood.
Mr. Tracy, Ms. Chandler.
No objection.
Okay. What are the case management deadlines that remain in this case?
Well, yeah, to that point, Your Honor, we've agreed that while we're negotiating on this stay, that we're going to extend the fact discovery deadline out. It's currently the end of this month, but we'll come up with something that makes sense and kind of depends on what we agree on the stay.
Is that correct, Mr. Nate?
That's correct, Your Honor.
All right. Mr. Tracy, anything else today?
No, thank you, Your Honor.
Nothing for me.
Mr. Nate?
No, Your Honor.
All right. Counsel, I wish you and your clients the very best. Please
Thank
take
you.
care. Court's in recess.